What an intro. Billy Joel. Hello and welcome to the first of what I hope will be the annual Thought Leaders for Fire Community Year in Review. I'm your host, your game show host today, Mary Young. 2020 started with fire. Australia was burning. We moved through storms Kira and Dennis, bringing floods to the UK in February, and then swiftly on to pestilence, where we stayed solidly for the rest of the year. But you've tuned in to hear about the end of the year, not the end of the world. And what a treat I have for you today. I've got 13 brilliant speakers from across the world and the fire community here to talk about topics from the return of the Crown Preference to the disappearance of the Black Swan. Although, because of restrictions on Zoom in China, I don't think Vicky Lord, who was supposed to be speaking about Black Swan, will be able to join us. So I think that means Black Swan has disappeared twice. Let's run through how this is going to work. Each speaker has 5 minutes to present on their topic, with the aim of persuading you, the audience, that theirs is the most interesting, important, and influential thing that has happened in 2020. While each person is speaking, you'll see that speaker and a large imposing timer, no pressure. When the 5 minutes is reached, we'll move on to the next speaker, whether the last one has finished or not. Now, because this is Zoom, and also to remind the speakers to check where they are in the order and be ready for their pitch, the way that we'll do this is by the next speaker turning their camera on about 10 seconds before the end, so that we have a seamless transition. Again, no pressure whatsoever. We've got a lot to get through, so I'm not going to be introducing each speaker. So instead, and so that you can see who's talking about what, there's a list of speakers in the chat function, and the speakers will of course all have their names on their screens in case you don't recognize any of them. When we've got through all 14 topics, or 13 topics, sorry, I'll start us off again, this time with 30-second replies on the subject, and all the speakers will be on the screen as they are now. Again, I'll post a list in the chat function so you have a point of referral. Then it'll be over to you to vote. Who persuaded you? Who was unconvincing? And how on earth did they summarise the 83-page Supreme Court judgment on Marex in 5 minutes, let alone, Sinead, respond in 30 seconds? Zoom only allows 10 options per poll. So we're going to have two lists of, one list of 7, one list of 6, I think. They are technically 2 polls, but we'll be relying on the honesty and fair play within the fire community to trust that you will only vote once. Thank you. In the meantime, this is supposed to be fun, so I encourage you to use the chat function to support your colleagues, comment, heckle, try to persuade me to dock votes from anyone, and ask any questions. I'm also encouraging buzzword bingo in these unprecedented times. If we have time, we'll have a look at the comments at the end before crowning our champion and declaring the prestigious Thought Leaders for Fire topic of the year. And we'll be trying to achieve all of this in just 90 minutes. So without further ado, let's start some fires. Let the games commence.
Thanks, Mary. Well, 2020 has certainly been the year of the remote trial. That concept didn't really exist before March this year, but jurisdictions all over the world have, by necessity, been required to embrace remote hearings and in particular remote trials. Even jurisdictions which are now COVID-free are still conducting hearings remotely or partially remotely where counsel or witnesses are not within the jurisdiction, which tells us that the concept is probably here to stay in some form at least. And that really is quite remarkable. In such a short space of time, there's been a massive and unprecedented change in the way that hearings are conducted and in the use of technology. 2020 has shown us that really, when pushed, the courts are in fact perfectly capable of conducting hearings remotely in most cases. If we cast our minds back to the beginning of the year, there was an initial flurry of adjournment applications due to COVID, and there was perhaps an expectation amongst practitioners that long trials involving numerous witnesses or a large number of experts, or those where translators were going to be required, would be adjourned until normality returned. But the courts pretty quickly quashed that idea. In March, the Lord Chief Justice of England and Wales issued a strong statement to judges saying, essentially, that hearings needed to continue, otherwise justice would become a mirage. He said that the courts would need to come to grips with technology, which previously would have been, in his words, unthinkable. And that is really what has happened. Trials have, by and large, gone ahead. Initially, there were some teething problems, and anecdotally, I've heard horror stories, for example, of a hearing recommencing after an adjournment without counsel from one of the parties being on the video call, because the judge forgot to do a roll call and everyone who was not speaking had their video turned off, so no one noticed. The issue was only discovered an hour or so later when it came time for that party's responsive submissions. But perhaps the major issue, which we've all had to grapple with, has been cross-examination of witnesses remotely. Now that's a real problem because good cross-examination has a rhythm and involves carefully watching the body language of the witness. When there is no shared courtroom experience, it's very difficult as a cross-examiner to get a feel for the witness and to develop an effective rhythm. Different techniques become more important when you're cross-examining remotely. Questions must be kept very short and to the point. Of course, discursive cross-examination is never a good idea anyway, but it's particularly difficult to follow when the witness is not in the same room. Add in some minor technology issues, a bad connection or a short time lag, and it's a recipe for disaster. And in cases where you need translators, the complexities just multiply. Cross-examination remotely takes longer than usual, and it will inevitably be less effective. That's just a consequence that advocates need to be aware of. Another problem the courts have had to grapple with is how to conduct private hearings and how to ensure that witnesses aren't receiving assistance. So far, the courts have taken a pragmatic approach, simply by reminding everyone involved of the applicable rules. And really, that's all that can be done. It's not perfect. But if we are to continue to have remote trials in the future, a better solution might need to be found. And finally, the B word, bandwidth. The biggest challenge facing remote trials so far has been a practical one. I have recently been involved in a hearing where the presiding judge could not see or hear the parties and repeatedly had to log in and out of the hearing. I've heard other examples of senior counsel not being able to log into a video hearing at all because of connectivity issues. So junior counsel needed to step in and do the hearing at the last minute. If we continue to have remote trials, better and more reliable technology is going to be imperative. But having said all that, it's extraordinary, really, how far remote trials have come in the short space of 8 months. And so for that reason, it's without a doubt the most important legal development of this year, and particularly unique to 2020. That's me finished.
Thanks, Liz. That's all very interesting, but I think the return of the Crown preference is actually the most important development of 2020. It's going to have such a massive impact on all stakeholders in the insolvency process. As we all know, on Tuesday, HMRC became a second preferential creditor, ranking after fixed charges and employee pref claims, but before the prescribed part, floating charge creditors and unsecureds. HMRC will now rank preferentially for all taxes collected on its behalf, so basically PAYE, VAT, and employee NICs. The amount HMRC can claim preferentially is now uncapped and time unlimited. Despite my youthful looks, I actually vaguely remember the early 2000s, and I seem to recall that before 2003, HMRC's pref claim was time restricted. The new HMRC pref status will affect lenders, borrowers, HMRC, suppliers, creditors, and IPs, and I think we can all agree that there could be some pretty wide-ranging effects here. It'll change the funding market, the approach lenders take in lending and recovering funds, and the way creditors and the public see the insolvency process. For HMRC, the return of their pref status is of course good fortune, or so it might seem. With COVID-related tax deferrals widespread and a likely increase in insolvencies in 2021, the PREF status could be great news for HMRC's insolvency bean counters. Having said that, the government itself estimates the anticipated tax take from this at less than 200 million, which is a drop in the ocean when compared to the cost of the COVID support measures. Practically, it seems inevitable that HMRC will have to take a more active and engaged role in insolvency processes. Its influence in CVAs will be even higher since PREF creditors can't be compromised. That could be a turning point towards the wonderful new restructuring plans with a potential for cram downs. While HMRC could really benefit are fire cases, so our kind of cases. In fraud cases, HMRC will now no longer be forced to sit alongside everyone else, but it'll be the legitimate trigger and preferred beneficiary of the process. For lenders and borrowers, the impact of the Crown preference will be sharply felt, as it will reduce the availability of finance for companies that are struggling or wanting to grow and invest. Floating charge finance will become less attractive to lenders and more expensive to borrowers. Lenders who traditionally rely on floating charge security can pretty much kiss goodbye to their likely recoveries unless their borrowers are more or less up to date with their taxes. That's pretty galling when the maximum prescribed part has just been raised to 800 grand. In the short term, given that there's no grace period on the 1st of December start date, lenders are going to see their returns from insolvencies reduce, which will probably lead to a greater reliance on personal guarantees where available. In fact, I suspect lenders will increasingly require PGs where fixed charges aren't available to top up their security. So borrowers will need to carefully balance the desire to grow their business with their own personal finances. Lenders might have to take a more active role in their customers' tax compliance, which might be a good thing because it could drive UK businesses towards better tax behaviour. But of course, increased oversight will lead to higher monitoring costs. I also suspect there'll be some attempts to mitigate risks to lenders by setting up more complex trading structures, maybe with payroll and sales compartmentalized into special purpose subsidiaries. Again, that'll come with risk and cost, and it'll be the borrowers that pay the price. And I guess that those costs will probably hit the SME market the hardest. There's been that figure thrown around a lot recently of the 1 billion of finance that will be removed from the market. I mean, even if that's right, I think the lending market is going to continue to adapt to the needs of its customers, but the cost of the Crown preference will be reflected in the pricing and availability of debt products. Thinking about IPs certainly will be reliant on high levels of engagement by HMRC, which is of course a good thing. And I say that because I'm not sure if there's anyone from HMRC in the webinar. Where IPs are going to face a great deal of frustration is when it comes to the unsecureds. I still remember hearing people complain in 2008 that there's no point in submitting a claim because the taxman will take it all anyway. And that was 5 years after HMRC ceased to be a preferential creditor. So it's funny that 17 years later, we're back in the same place. Those at the bottom of the food chain who already receive pretty much similar returns anyway will be overlooked yet again. And it's quite ironic that this comes after years of well-intentioned but over-engineered changes to insolvency rules aimed at increasing transparency and creditor engagement. We're likely to see unsecureds engage even less with the insolvency process, I think. Instead, the suppliers that usually become unsecured creditors will probably look towards shorter credit terms or credit insurance, which is only going to impact on companies' flexibility and ability to trade, making dealing with things like pandemics and Brexit even harder. While we'll have to wait and see what the real consequences are going to be, many of us are expecting fairly dramatic changes to the lending market as well as public attitude towards insolvency. And I think it's those changes that will shape the future of the fire market. And that is, I think, why the Crown preference is the most important change of 2020.
Thank you. Okay, my role over the next few minutes is to explain why the SFO is the most significant contributor to legal developments in fraud during this difficult year. The SFO have been involved in many worthy contributions over the years in tackling global corruption and the most complex and difficult types of fraud. We're not talking about singular issues such as developments in insolvency or new case law in offshore jurisdictions, or indeed banking issues, for example. The developments I'll be taking you through will show the truly global reach that SFO investigations entail. We all understand the damage that fraud, corruption, and money laundering does to our society and economy. And for that reason, any action taken by the SFO, whether we are focusing on its successes or failures, will always contribute to important legal developments because this paves the way for how future investigations and prosecutions are handled. Now, I'll only go through a couple of examples. The first example relates to corporate criminal liability, such as deferred prosecution agreements, or better known as DPAs. The concept of DPAs come with many issues that are still surfacing today and that our own courts are still developing. A DPA is basically a mechanism where a company admits to wrongdoing and agrees to meet certain criteria to avoid prosecution. It's a non-trial resolution focusing on corporate entities. And in practical terms, the SFO's message is simple: comply or risk facing jail time. Now, despite all of the difficulties that are presented with corporate criminal liability offences, the SFO managed to secure a record-breaking DPA with the aerospace manufacturer Airbus, in which the company paid a fine and costs of 991 million euros in the UK and 3.6 billion euros globally. This DPA is the world's largest ever global resolution of bribery and corruption charges. I mean, the conduct covered by this DPA took place across 5 jurisdictions, including Sri Lanka, Malaysia, Indonesia, Taiwan, and Ghana. Now, I would say this case on its own stands as the most important legal development in 2020. Just look at the results. Global resolutions and fines of this size, we're talking blockbuster figures, which are very rarely seen. The SFO played a major role in this investigation, but also managed to successfully coordinate with the French and US authorities. And this again shows the significance of the development. I mean, it shows the importance of engagement, partnership, and how to utilize intel between different agencies in order to reach the same goal. Moving on then to my next example, you'll all be aware of how quickly the landscape changes in this sector, from keeping up with the digital world and also adapting to new norms because of COVID-19. Despite the pandemic, the SFO have been successful in high-profile convictions and also managed to open up new investigations in recent months. Now, any fair assessment of the SFO must also consider their failures as well as their successes, because this also impacts legal developments. For example, in February, we saw the acquittal of 3 Barclays executives who were acquitted of fraud that related to the 2008 financial crisis. And this again gives an insight of the SFO's success rate. I mean, if you were to look at the recent publication, the SFO's annual report, that was also tainted with question marks. I mean, it suggested a 62% conviction rate after trial. So in conclusion, the SFO is not without its faults, and there is a tough road ahead to satisfy doubts and critics of how the SFO styles its prosecutions. But having said that, it has to be the most important legal development because of the magnitude of cases it has brought this year, in particular, the 3.6 billion euro settlement with Airbus. Now, I've actually got a few seconds left, so I'll take this time to say, you'll hear from a lot of us today, but bear in mind what I have said. I think it's the right thing to do to vote for this topic, and it's a topic that I am extremely passionate about.
Thank you. Yeah, nice try. Okay, everyone. Hello, I'm Rick Brown. I've got 5 minutes to persuade you that the issue of the Quince care duty is the most important fire topic of 2020, and an easy task, I hope, because there's no hotter topic right now, and I genuinely think that we're going to be talking about this as we go into 2021. I'm going to tell you why. I've got a very, very short amount of time to do that. First, a reminder, the Quince care duty was first established back in 1992 in the case of Barclays Bank and Quince Care. It set out the duty between a bank on the one hand and its customer on the other, namely that banks owe a fiduciary duty to their customers in both contract and tort to execute the customer's instructions with reasonable care and skill. All sounds pretty obvious, I know. But what does it really mean? Well, it requires a bank or any business that holds client monies, and that will be relevant, to hold off from processing a payment instruction from a customer if it has reasonable grounds for believing that the payment is an attempt to misappropriate funds from the customer. So it doesn't need to have proof, it just needs it needs to have reasonable grounds to believe that. And if it's got those grounds, then it should refrain from making the payment pending inquiries about the bona fide nature of the instruction. And all of this, of course, bumps up alongside a bank's regulatory anti-money laundering obligations and so on. But for these purposes, we're just talking about the civil law claims. All very interesting, I hear you say, but until recently, the duty had quite limited judicial consideration. And then, like buses, 2020 also saw a number of commercial court cases and brought before the English courts where claimants have sought to get at the deep pockets of financial institutions for alleged breaches of the duty. And the scope of the duty, or at least its interpretation, is getting wider, which is obviously good for claimants, not so good for banks. And it means that we're going to see a rise in these kind of claims as we move forward in the coming months, which is why it's so important right now. 4 cases to mention in very short order. I'm not going to obviously go into any detail. The first was the Supreme Court decision in Singularis and Daiwa, which, to be fair, was at the end of 2019. But it will the influence of it trickled over into 2020 with 3 further decisions: JP Morgan and the Republic of Nigeria, Hamblin and World First, and Stanford International and HSBC. I obviously can't talk about them in detail, but I'm going to call them cases 1, 2, 3, and 4 and give you a quick sentence or two in respect of each of those. So in the first case, the Supreme Court allowed liquidators of the claimant to recover sums paid away by the bank at the instruction of the fraudulent controlling mind of the company. And crucially, it also rejected the bank's defense of illegality because the court said that had it allowed that defense, it would denude the duty of any value in cases where it's most needed. So a big victory there for insolvency office holders and claims which they might want to bring. In the second case, the Court of Appeal clarified that financial institutions can actually agree to exclude the duty, provided that any such exclusion is both express and sufficiently clear. So one for the banks there to sit up and pay attention to. In the third case, the High Court held, admittedly at first instance, that financial institutions may be liable for breaches of the duty, even if the customer's net assets have not been reduced by the breach. Quite surprising, I think, and the details are a little too complicated for this very short period of time. But the takeaway point from that case is that where a claimant is insolvent, the court is prepared to find that the claimant has been deprived of sums which ought to have been available to it in the insolvency. Okay, so it was only a preliminary finding, and HSBC can run its arguments at trial, and therefore definitely one to watch. But for the time being anyway, another boost for insolvency practitioners, and certainly one to keep an eye on. And in the fourth and final case, the court appears to have widened the scope of who has the duty by implying that financial institutions should be interpreted more widely, not just to banks, but in this case to a payment services provider that had provided current account banking facilities. So that analysis, let's be frank, is going to be stretched in future, and one for claimants, lawyers to think about and get creative about. So 4 cases showing the importance of the Quince care duty and why it's a worthy winner of your vote. As a parting comment before I hand over, I'm quietly confident in my prediction we're going to see more of these claims next year, especially as we're faced with either a wave of insolvencies where insolvency practitioners are going to want to take aim at deep pockets wherever possible, or where victims of fraud will want to seek redress against those very same deep pockets. So that's me done. Thank you very much. Happy Christmas. Vote for me.
Well, a predicted wave of insolvencies is a good place for me to start, because 2020 should have been the biggest year for insolvency in recent memory. The UK's GDP fell by an eye-watering 22% in the first half of the year. And even after something of a rebound, it looks like GDP will be down at least 10% year on year. According to the ONS, some 14% of UK businesses have little or no confidence that they will survive the next 3 months. And in the hospitality sector, that rises to more than a third. That is a major downturn by any historic standards. But despite all of that, it seems as though the only uptick in appointments this year has been appointments for COVID tests. Indeed, in October, insolvency filings overall were down in the UK by 42% compared to the same month last year, when economic conditions were relatively benign. Compulsory liquidations fell by a stunning 76%. So what accounts for this? Is this the story of the incredible stoicism of good old solid British business? Well, no, this is where I finally get to the punchline. This is the story of an extraordinary statutory experiment, the Corporate Insolvency and Governance Act of 2020. And that legislation is the biggest story of the year. SIGA, as I shall call it, was announced in March, drafted in April, published in May, and enacted with retrospective effect in June. And in just 3 months and relatively little fanfare, the UK government had unleashed a quiet revolution on the UK insolvency industry, and one whose effects will be felt far beyond UK borders. It's because of SIGA that since March and well into next year, statutory demands for UK companies have been void. And so that means petitioning creditors can no longer rely on a presumption of established insolvency by an unsatisfied statutory demand. And instead, to get a winding up order, they'll have to prove insolvency, and more still, satisfy a court that the insolvency would have occurred without the financial impacts of the coronavirus pandemic. All of this makes winding up petitions practically impossible and a huge cost risk in the vast majority of cases. Added to this, SIGA has also preemptively absolved directors from any liability for wrongful trading from March until at least April of next year. So it's no wonder then that insolvency filings have fallen off a cliff. SIGA's temporary provisions, when coupled with blanket restrictions on forfeiture of commercial leases, are little short of an economy-wide moratorium. This is quite an experiment in what has historically been one of the more creditor-friendly insolvency regimes in the world. And this extraordinary pro-debtor culture shift is not intended to be temporary. Indeed, SIGA has also introduced major permanent changes to the UK insolvency law in the biggest shake-up since the Enterprise Act nearly 20 years ago. Those reforms reveal the same debtor-friendly trend. We have a new freestanding moratorium, which is the UK's first debtor in possession procedure. And we have a new restructuring plan with its tongue-twisting cross-class creditor cram-down. Thank God I got through that. And incidentally, both of these new insolvency procedures are available not only for UK companies, but also foreign companies with a sufficient connection to the UK. And finally, SIGA has brought in new rules which prevent suppliers from terminating their contracts with insolvent companies and keep them bound to maintaining supplies unless they can demonstrate to a court that doing so will cause them hardship. Now, we don't know yet what the outcome of this bold SIGA experiment will be and the radical culture shift towards a pro-debtor insolvency regime that's being attempted. But perhaps sometime in the near future, as the COVID pandemic recedes into memory, a newly Brexited Britain will rise phoenix-like with a V-shaped recovery, and a heroic band of rescue-focused, debtor-friendly insolvency practitioners will lead the way for us all. Or perhaps, in the aftermath of the pandemic and a year of unregulated mass insolvent trading, insolvency practitioners will be faced with cleaning up a train wreck of creditor losses, financial misfeasance, and zombie companies, prompting a reactionary backlash to the pro-debtor revolution and a revived focus on creditor protection. Either way, or wherever we are in between, SIGA has set up a fascinating and busy 2021 for us all. Thank you.
Sorry, you caught me by surprise here. I'm going to talk to you about freezing injunctions. Being the only civil law jurisdiction lawyer among the crowd, I could have well decided to talk about Swiss freezing injunctions, but I believe that it would be of little interest to the general audience. I might also have wanted to compete into my own category, but I will have decided to agree to accept the competition of my common law colleagues. For decades, I've been, of course, jealous of common law WFOs, and I thought that I would take this opportunity to talk to you about a case happening this year, in which we were involved in what we could call a Swiss WFO. And this case actually involved also the coordination with English proceedings, which make it of interest, I think, to common law lawyers. Essentially, a dispute arose between Integral Petroleum SA, Geneva Petroleum Trading Company, and bank GPP International SA, a Luxembourg bank, a subsidiary of Gazprom Bank, regarding a line of credit that had been issued by the latter to the former. So on 21st of July 2020, GPB filed a request for immediate bankruptcy or winding up of Integral based on an alleged general suspension of payments to its creditors, and as well as allegations of fraud. In addition, GPB requested ex parte interim measures in support of its action, requesting an order prohibiting Integral from disposing of its assets worldwide and ordering Integral to disclose its assets to the Geneva Bankruptcy Office. So the order was granted ex parte, and you have in effect approximately the same consequences as a WFO. So the order was served on Integral, and Integral on 30th of July 2020 filed an application for an anti-suit injunction before the High Court of London. The application was dismissed on 7 August upon GPB offering undertakings to relax the terms of the freezing injunction in Switzerland. And we, FDA approval, evidence that hackers are targeting the critical supply chain. And we had the opportunity actually to apply with the Swiss courts to indeed relax the injunction on behalf of Integral. In the meanwhile, WFO was also ordered in England against Integral shareholder for up to 23 million. So we were in a period where we had two concurring WFO, one Swiss, one English. On 9 September, however, the Court of Geneva dismissed the action for winding up of Integral and discharged the interim measures. The matter is still in appeal, but it's likely that the measures are not going to be maintained since the Court of Appeal refused to grant the stay effect. So I believe this is quite an interesting case of interaction between Switzerland and England in terms of freezing injunctions and particularly WFOs. And I believe that it would deserve at least to be the most important among the civil law jurisdictions represented here, and possibly some votes also for the general matter. Thank you all.
Thanks, Yves. The search order imaging order discussion came about due to a Court of Appeal decision, TBD, against its very naughty former employee, Mr. Simmons, G2A, TBD's competitor, and a few others. Mr. Simmons took the liberty of taking some keepsakes when he left TBD's employment and joined G2A, who used the materials when it approached TBD's customers. What could go wrong? Mr. Simmons swore blind that he didn't have any of the material and then admitted deliberately misleading the claimant and the court, and that he'd made gross errors of judgment. Anyway, TBD and its solicitors made an absolute dog's dinner of enforcing the search order, and why we're discussing this case. So a little history lesson. Did you know the first search orders were made in 1974? They were made pursuant to without notice applications to judges of the Chancery Division in cases of alleged infringement of IP rights, and became known as Anton Pillar orders further to that case in 1976. Over the next couple of decades, there was a bit of a muddle in terms of the distinction between the evidence-preserving functions of the Anton Pillar order and disclosure orders. In 1997, Parliament enacted the Civil Procedure Act. Now, Mary, that would have got the Crimbo Showdown Award of that year, which put Anton Pillar orders on a statutory footing, and the CPR were introduced and renamed Anton Pillar orders as search orders. The standard form of search order, having been developed over the course of the last 25 years, is still in use today, and you have to have a good reason to depart from it. The Court of Appeal did a canter through the cases and found three fundamental principles not necessarily relevant to this debate, but worth remembering. The first being that search orders are for preserving evidence necessary for the plaintiff's case. They are used to prevent a defendant from burning everything or flushing it down the toilet. And the purpose of inspecting documents during the course of the search is to identify documents which should be preserved, not to have a good sniff about. Two facts that justify a search order may also justify the making of without notice orders for disclosure and inspection of documents and or the preservation and or the provision of information. However, the two types of orders are distinct, require separate justification, have different effects, and must not be conflated. 3, all such orders must contain proper safeguards for the respondent, and those safeguards must be respected during the execution of the order. The safeguards required for without notice orders, for the disclosure and inspection of documents and the provision of information are different to those required for search orders. The Court of Appeal recognised that time has moved on, 25 years. We have become digitalised and all have digital devices and iCloud storage. So high time for the imaginatively named imaging order. On the positive side, it is relatively non-intrusive. You don't need to remove documents. It gives the computer geeks an outing. It enables all digital evidence to be preserved for subsequent analysis. The key disadvantage is that you can't tell between information that is relevant to the issues in the proceedings and information that is irrelevant, or between business information and personal information, or between information that's subject to legal professional privilege, or between information that's not. You're getting my gist. Thus, imaging can only ever be a preservation step, and it must be followed by proper consideration of the issues for disclosure and inspection of documents. So, what to do with all these images? It's getting expensive. You can use keywords, but they may impinge on the defendant's privacy rights as well as those of third parties. How can you prevent privileged material from falling within the search hits? How do you protect the defendant in circumstances where the claimant and defendant have competing businesses and the defendant's got sensitive business plans? So, are imaging orders the answer? The Court of Appeal held that if an imaging order is made, then that may make traditional search orders unnecessary, or at least may enable the scope of the search order to be significantly restricted. Actually, I think there's an interplay between the two. Take, for example, an asset search. You often need to move quickly. Invariably, you're looking for a needle in the haystack with the amount of information you've got. It's too expensive to run searches for gold, diamond, all your usual stuff, unless under the threat of committal, and note Jason's less important update, which is following, you get assistance from the defendant as to his file structure, location of documents, etc. As such, I think you'll need to get the defendant's assistance there and then. So if I haven't showed you so far, news to say the Civil Rules Committee is being rolled out to introduce and produce a standard form of imaging order. What could be more important than that? Thank you very much.
Well, thanks for that. My worthy opponents would have you believe that all sorts of somewhat interesting cases and legislative changes from somewhere not in the British Virgin Islands or the Cayman Islands were the most significant developments in the fire space of 2020. But they're wrong. Whilst I accept that there have been at least 4,739 days of this godforsaken year so far, and thus so many trends, developments, and memes to pick from, it is very difficult to choose. But you'll be delighted to hear that your vote will be safe with me. And in any event, Rudy Giuliani is a pal of mine. So if you don't vote for me, he'll file a lawsuit delaying the count until I win by default anyway. So I'm quite sure you'll just embrace the inevitable anyway. Okay, so whilst I know that what you want me to say is that the meme of Lizzo as the fly on Mike Pence's head was what moved you in 2020, me too. But after hearing my pitch, you'll soon agree that the absolutely stellar, rocket to the moon and back, knock it way, way out of the park, turning somersaults development of 2020 has to be the monumental developments in provisional liquidations down in the islands. That's right. Whilst we insolvency litigators here have been paddling out with our surfboards in the warm Caribbean Sea, dodging the most active hurricane season on record, sipping our dark and stormies and waiting for that one big wave of insolvencies that has never quite appeared, We've also been doing great things. In fact, the greatest things for global restructuring. In fact, nobody has done more for global restructuring than us. Firstly, in the BVI, we've had the first ever soft touch provisional liquidation. This neat little restructuring tool essentially makes up for the absence of Chapter 11 and has now helped about a gazillion oil rigs worldwide stay afloat. And I ask you, my avid listeners, what knowledge could be more comforting and persuasive in the year of the climate crisis than that? Whilst provisional liquidators are appointed, their roles are carefully dovetailed with the existing board of directors who stay in place to helm the boat through the restructuring. The case also means that it's now beyond doubt in the BVI that a moratorium on adverse creditor claims can be obtained from the court, and thus sneaky little rapid-fire litigant creditors can be stopped in their tracks and made to form an orderly line with the others. Secondly, in the Cayman Islands, recent restructuring judgments, also in soft touch provisional liquidations, have demonstrated sensible limits and restraints being placed on the ability of distressed companies to explore restructurings using this tool. The problem has been that whilst a restructuring is explored and a restructuring plan perhaps developed, the appointment of liquidators is avoided, and certain explorations have taken an awfully long time, and creditors have vociferously complained that they've been held out of their money for an interminable frolic. Well, the Cayman Court has now stepped in to ensure that in those cases where the prospects of a successful restructuring are perhaps more debatable, it may decide to empower independent provisional liquidators to explore restructuring on a tight timetable and report back on its viability to the court and creditors, rather than leaving it to the company's board, thus ensuring the effectiveness of the soft touch provisional liquidation tool in the Cayman Islands. Moving on from the party pooping and onto the meat of my pitch, like any good lawyer or Trump supporter, all I'm asking you to do today is overlook the facts, ignore the eloquent and legal technical arguments, or even the science and statistics thrown at you by my opponents, and just follow your instincts. What could go wrong? Put simply, you need to vote for me because Caribbean provisional liquidators, ravaged by the events of 2020, the COVID pandemic, climate change, the US trade war, and the very deeply sad and economically significant loss of the Duchess of Sussex to Los Angeles, well, they all need your help. I want you to think of all those lovely provisional liquidators you know as we approach Christmas. And I bet they're much like Tiny Tim, every last one of them, bless their little hearts. And vote for giving them all nice little jobs at Christmas. Vote for them by voting for me. Make provisional liquidators great again.
Right, 5 minutes to tell you what you already know, which is that the Marex decision of the Supreme Court is the most significant issue of 2020. What was Marex all about? Very simply, Marex got a judgment for about $5 million against two BVI-based companies. The director, Mr. Sevilla, on receiving draft judgment, looked through his book of Dick Dastardly Acts of the Criminal and decided to transfer $9.5 million out of the company's bank accounts and put the companies into liquidation. In that liquidation, Marex, with its judgment, was the only non-connected creditor. They then sued Mr. Sevilla in tort. At first instance, the judge decided that the position on reflective loss did not stop Marex's claim and rejected the principle that if that was the case, it would be ridiculous and render economic torts redundant. Unfortunately, the Court of Appeal overturned this and said that the principle of reflective loss applied to creditors as much as shareholders, where the loss to the creditor merely reflected the loss to the company and throughout the claim. But the Supreme Court came to the rescue, as it often does, donned their capes and reviewed this case and the reflective loss principle. There's a majority and minority decision, which I know you will all have read ad nauseam. Both are significant. The majority decision from Lord Reed said that the scope of reflective loss had been expanded too far, and he refined it with the majority of the court to only apply to shareholder claims which relate to a diminution in value of shares or distributions that result from a company having suffered loss where that company has a claim against the same wrongdoer for that loss. The minority decision, which perhaps might be even more interesting, described the whole premise of reflective loss as flawed. It said that in most cases, shareholders suffer a very different loss to the company, even if it arises from the same action from the same wrongdoer. They made the point that even if the company recovers the loss suffered from the wrongdoer, the shareholder is unlikely to be restored to the position he would have been or she would have been, and therefore that loss remains. The minority said, perhaps dramatically, that the whole approach of reflective loss ought to be binned, and instead a court should look at whether the loss is the same, and if it is, simply reflect that in the calculation of each claimant's loss to prevent double recovery. So why is it important? Well, firstly, it's a case about BVI companies. And other than a couple of members on the panel, I don't know about you, but that's as close as I'm going to get to a foreign holiday reading about one. And that makes it significant in this year. It's also a case which allows people to do something which they were previously not allowed to do. That seems to me the perfect antidote to 2020, where exactly the opposites occurred for the majority of us. But on a legal basis, why is it significant? It turns back decades of expansion of the reflective loss principle. It opens up claims for creditors and shareholders and other non-shareholders for losses suffered and caused by miscreant directors. So it gives creditors a real voice and a real weapon against fraudster directors and misfeasant directors. It also adds a weapon against corporate fraudsters, which had previously been subject to limit by the reflective loss principle. It revives economic torts, which have been rather subdued by the reflective loss principle. And as the judge in Marex in first instance said, they have an important part to play when fraud's been committed by directors. It also has a reach beyond England and Wales. Reflective loss is a common principle in other Commonwealth jurisdictions. This decision of the Supreme Court will therefore reach from one end of the globe to the other in terms of determining matters going forward. The minority judgment might be said to raise the most interesting issues that corporate litigation's had for nearly 200 years. It questions seriously whether the Foss and Harbottle rule back in 1843 should remain. That's one of the longest surviving concepts in corporate litigation. If this case is reviewed by a Supreme Court in the future that has the same view as the three minority justices in this decision, it opens the possibility of that rule being removed in its entirety, giving shareholders free rein to pursue their own losses, even if they mirror those of the company. In short, this is earth-shattering and changing. Frankly, you and I both know this is all that the TikToking teenagers of our generation have been talking about for months. It's for that reason that you ought to give it your vote.
I hope everyone's still awake. Right, unexplained wealth orders. For my money, the source of which I can explain, is the topic of the year and of our times. And let me tell you why. I'm going to use a story you will all know. Wind in the Willows 2020. Once upon a time by a river lived Toad of Toad Hall. Was he a PEP, a politically exposed person, or did he have unexplained wealth believed to be connected to serious crime? Or was he a PEP of a more innocent type? A pompous, eccentric playboy. Certainly, he had the trappings of unexplained wealth, a stately mansion with a sumptuous banqueting hall, a fleet of shiny red cars, and no job and an idle lifestyle to match. Someone, though, was envious of Toad, someone who had nearly been run over by Toad as he careered along country roads, honking his horn and shouting, "Loot, loot!" Enter Ratty, a rat by name and by nature. For Ratty had written an anonymous letter to Toad's bank, you've guessed it, the River Bank, tipping them off that Toad was a crook and whose accounts upon inspection revealed a recent, very expensive spending spree in Harrods. The red flag was up and a SAR, a suspicious activity report, was posted. Quick as a flash, Chief Willie Weasel and his deputy Simona Stote of the SFO, not the Silly Ferret organisation, as some now call it, more of which later, whilst on secondment to the NCA, were at the High Court applying for an order, an unexplained wealth order. Ex parte, not on notice, as they like to keep things underground. An order requiring Toad, whether as an individual or a company, to fully explain in a statement how the listed assets came to be his, the burden being on him to prove they were legitimate. For Lord Justice Moley was satisfied on the balance of probabilities that Chief Weasel's beliefs were reasonable and that Toad had unexplained wealth to answer for, even though Toad had been convicted of no crime. So Moley LJ froze Toad's assets, requiring Toad within a certain number of days to comply with the order and explain how he had legitimately acquired those assets, and as an aside, in doing so perhaps alert Chief Weasel to a bigger case than first thought. And if Toady were not to comply, he would be guilty of a crime worth 2 years in prison and could be committed to jail for contempt and have his unexplained assets seized under a civil recovery order under POCA, which we all know stands for the Proceeds of Crime Act and not, as Toad thought, the pleasures of carefree animals. The judge also ordered Chief Weasel to serve a transcript of their chat and that there be full disclosure of all material facts as part of Weasel's duty of candour, a duty which didn't sit easily on a Chief Weasel's shoulders. Oh, poor terrified Toad, a life of penury and prison beckoned, but Toad was not alone. He had a reliable and knowledgeable friend, Brenda Badger of Kingsley Napley. Fear not, Toad, said Badger, we can challenge this, either by showing your wealth was inherited or gifted property, so the legitimate provenance of the property in question, or that you are not a person on whom an unexplained wealth order can be served. And upon hearing Badger's advice, Toad sighed with relief and blessed the fond memory of Aunt Agatha and her fading letter of wishes bequeathing Toad his wealth. And it came to pass that the order was discharged, Toad's assets were unfrozen, and Harrods Food Hall beckoned once again. And the moral of the story is, beware. For the UK enforcement agencies have called time on organised criminals of any variety and corrupt public officials who seek to launder criminal funds through the UK. So this must be the law of 2020. These orders are easy to obtain, with no evidence of wrongdoing required, with the toadies of this world required to do all the work or lose everything. So whilst Toady was triumphant in this story, many in 2020 have not been. And breaking news from Scotland, Toady's mate Donald T may need Brenda Badger's expert advice in the very near future. Now surely that must be a vote winner. The end.
Good afternoon, everyone. I'm Jason Woodland from Peters & Peters, and I'm going to persuade you today that the changes to the contempt procedural rules are by far the outstanding highlight of this year. As I hope you can all see, I've got a subject appropriate background on. It's a prison, not a battery farm, just in case anyone was wondering. Because let's be honest, we all like contempt applications because we get to send people to prison. Criminal lawyers like to think they have the best stories, and contempt applications are the closest us civil lawyers will get to that. I once made the mistake of telling my then 8-year-old son that I had had someone sent to prison at work. Since then, every time we talk about our day, he asks whether I've sent anyone to prison. When I inevitably say no, he's not interested in anything else, not even the disclosure pilot scheme. So I'm glad the audience today is a group of such well-regarded and prestigious experts, because some hard-of-thinking people might wonder, why on earth is a change to the procedural code regarding contempt applications the highlight of the year? In years to come, when historians look back at 2020, what are they going to think of? Not the coronavirus, but the magical day on the 1st of October when the new CPR 81 came into force. I'm sure you all remember where you were on that day and when you first read the new rules. I could talk all day about the dramatic changes introduced by the rules, such as changing applicant to claimant and respondent to defendant, but I'm going to focus on a couple of changes which might have a practical impact and which you should keep in mind. First are the rules regarding service. I'm sure we all remember fondly racing around in taxis, hiding in bushes in order to serve someone personally with a committal application. It was either that or undertaking tortuous negotiations with the other side about service by appointment, which would make the Brexit talks look like a walk in the park. But there is now a way around that in Rule 81.5. If there is a legal representative on the record in the proceedings in which the alleged contempt was committed, that legal representative can be served. So far, so good. We then descend into an Alice in Wonderland world where that is taken to be good service unless the legal representative objects in writing within 7 days. If the lawyer does object, then the matter is referred to a judge who will consider written representations from the parties and determine the issue on the papers, and usually without a hearing. No need for any application for service by an alternative method or anything like that. You might ask yourself, what issue? Because it's pretty obvious what decision a judge is going to come to. And unless there is some pretty convincing evidence why further steps are needed to bring the application to the attention of the defendant, the judge is going to consider that service was good. Once the application has been served, there's a requirement for the court to give directions. The rules don't say whether the directions are going to be given automatically on the papers or at a hearing. And I suspect for most applications, there'll need to be a short hearing. But in straightforward cases, it may be possible for it to be dealt with on paper, and you might want to think about making an application for those directions when you put in the committal application. And finally, there is a useful list of items which need to be included in any committal application in the new Rule 81.4. And if you have all of those items in your committal application and the evidence, you won't go far wrong. Now, you might think that those changes in themselves are not groundbreaking, and you'd be right. But it is of significance that streamlining and clarifying these rules was thought to be a necessary exercise. And that's because there has been an increase in committal applications over the last couple of years, and the powers that be are obviously anticipating an avalanche of them. And that is why these changes are undoubtedly the highlight of the year. Thank you.
So hello everybody. In a quick nod to our marketing department and anyone following the live chat, Santa Claus and I are here today to talk to you about why Guernsey's insolvency law changes are so important. As you can imagine, I was delighted to be asked to participate in this event and comment on the most significant developments in the industry in this most extraordinary of years. I was less delighted when I saw the list of big ticket topics of SIGA, Crown Preference, Marex, only to be told that my topic was changes to Guernsey's domestic legislation. But to overlook this subject would be to do a grave disservice to the achievements of one tiny lump of granite positioned 20 miles off the French coast, and here is why. There's no doubt we're all sick of those big headline grabbers of Brexit, COVID, but they do hold the keys to why Guernsey's updates to its existing insolvency regime are so important and so relevant in the current climate. What Guernsey's managed to do is to address two of the biggest cross-border issues in our arena with some subtle but effective changes, and in doing so has shown up some of the major onshore jurisdictions whose changes are less sensible, but more to come on Crown Preference later. Big issue number one right now is COVID-19. The distress caused by the pandemic is undoubtedly going to drive workflows in our practice areas for the foreseeable future. Be that in terms of restructuring debt, formal insolvency processes, or the recovery of assets later on. Having the correct tools in the box to deal with these issues is of tantamount importance to any jurisdiction. Offshore, Guernsey already leads the way in terms of its domestic insolvency regime. Does anyone remember when Donald Trump tweeted that the Americans had harnessed electricity, split the atom, gave the world the telephone and the internet, as well as winning 2 world wars? Well, in the same way, anyone would think that English lawyers came up with the concept of light touch administration in response to the pandemic. That's rubbish. Guernsey did it in 2008, since when, unlike any of the other major offshore centres, it's had a domestic administration regime that has, through its inbuilt light touch approach, been used to handle a number of complex and high-value cross-border insolvencies on island. The vast majority of changes that are now proposed to Guernsey's domestic law are simple but effective refinements to the existing processes that will enhance the current regime. Briefly, the changes encompass improved protections for creditors whilst keeping reporting requirements light touch, an improved proof of debt regime, and the introduction of insolvency rules that can be created quickly to adapt the system to the changing economic drivers. Those changes are important because they are manageable, and they're effective in ensuring that Guernsey can continue to deal with the flood of issues that many predict is coming on island. That will obviate the issues that inevitably arise if an offshore company is shoehorned into an onshore process. One such issue is recognition, which leads into big ticket issue number 2, Brexit. The other major area of change proposed for Guernsey's regime is in terms of the investigatory powers afforded to office holders. These are being beefed up significantly to provide Guernsey office holders with the teeth they need to secure information to allow them to maximise asset recoveries. Why is this important? Well, the UK's crash out of the EU brings enormous uncertainty in terms of recognition of insolvency appointments. The current understanding is that post-Brexit, the automatic recognition the UK has enjoyed across Europe will be turned off. That leaves you with 2 options. The first, very limited one, is recognition pursuant to Section 426 of the Insolvency Act, another area where Guernsey has played a blinder in terms of adopting that section into domestic law. But absent that, you may be faced with the prospect of common law recognition as your only option. In those circumstances, and here comes another buzz phrase, post singularis, having robust domestic powers available to insolvency practitioners, like those that Guernsey is introducing, is the key to being granted similar powers in your requesting jurisdiction. So what that means again is that Guernsey's got itself in front of the curve to ensure that its office holders and those coming here will be much better placed to rely on investigatory powers that they have at home if they're forced to seek common law recognition. And so I'm urging you to vote for Guernsey, because whilst the reforms that Guernsey's making to its regime may seem insignificant, in the grander picture of the very adequate presentations you've heard from the others, the key takeaway is the effectiveness of the changes in dealing with the fallout from the 2 really important events of the year, the pandemic and Brexit. So vote for Guernsey and vote for Santa.
Now, there's a reason that this topic has been left to last on the list. You always save the best until last. Now, getting service right is critical. It engages the English court's jurisdiction over the defendant. From a claimant's perspective, if service is wrong, the claim may be struck out, or if limitation is an issue, it may be time barred. Very important. There are important time consequences for a defendant as well. Service sets the clock ticking on its response, and a failure to react in time will leave it on the receiving end of a judgment in default. Very, very important. Now, no one ever wants to get tied up in knots over the thorny issue of service. Certainly no one wants to speak to their PI insurers about service either. Service gives life to a claim, but it can also be the cause of death. It can be your friend, but it can also be your foe. Like it or not, service is the most important step in legal proceedings. And what a year it has been for service. There's been ups, there's been downs, there's been twists and turns, cold sweats, sleepless nights, and anxiety across the country thinking about service. I could spend a whole week talking to you about service, but I only have 5 minutes. So instead, what I'm going to do is to captivate you all with the 2020 highlights, a bit like Match of the Day, but this is not a game. This is real life. Real people have been involved in the stories that I'm about to tell you. So let's start. While we have seen a few changes this year, to put it mildly, service of court documents has not been one of them. In fact, it's probably the lack of change that is most notable. But fear not, there are highlights. When the lockdown took effect towards the end of March, offices were shut, we were all sent home, and paper and hard copies rapidly started to feel like something from a bygone era. Many were speculating whether there would be a shift in the rules on service. After all, many measures were introduced by the courts to facilitate other things, such as remote hearings. So it was not unreasonable to expect perhaps a little something for us, perhaps a change or a tweak, just to allow us to use service by electronic means. But no, nothing. Zilch. Anyhow, there wasn't a change in the rules, but there was a change in working practices. One case in particular highlighted that while the rules stayed the same, the courts will still expect parties and their legal representatives to react to the circumstances. This case was Stanley versus London Borough of Tower Hamlets, which was heard in the QBD back in June. In this case, a letter before claim had been sent to the council in January this year, to which there was no response, nor to a follow-up a month later. The claimant telephoned the council in February to confirm whether it would accept service by email, but they were told that service had to be by post, and email was unacceptable. 23rd of March, the council shuts its offices. 25th of March, the claimant posted its claim form to the council's offices. By April, default judgment was obtained. The council sought to set this aside. Was it unreasonable to effect service by post? The claimant said no. It was doing purely what the council had told it to do. Mr. Justice Knowles took a different view, however. It was not good enough for the claimant to say it had been told in mid-February to serve by post. The world had shifted on its axis on the 23rd of March 2020. It was incumbent on the claimant's solicitor, as a reasonable and responsible solicitor and officer of the court, to contact the council again to discuss the best way forward. It was not fair or reasonable to simply place the papers in the post. Well, there's a lesson learned. So, what about litigants in person, I hear some of you ask? Well, there was further confirmation, if any was needed, that litigants in person are expected to follow the rules as much as anyone else. You probably all know about the case of Ivanchev versus Veli, a big case. It was a huge, terrific case. The claimant was tripped up by a failure to prove that the claim documents had been placed in the correct mailbox at an apartment block. In that case, a process server had been engaged, and this was in fact their second attempt, having tried to effect service wrongly at an adjoining block. On the second attempt, they were not permitted to place the documents in the mailbox by the security guard who was on duty and who did it himself. So the claimant was unable to supply the necessary evidence to the courts. As I suspected, I was going to run out of time on this huge topic of service. Remember, service gives life to a claim. It can also be the cause of death. Next year, service may make many enemies. Vote for service, the most important time.
Well, I am exhausted just from watching that. What a first round. And I don't think I've ever been at a seminar which has made me laugh so many times. Who's your front runner? Will Jen and Rudy get your vote on making provisional liquidations great again? Did Jason's service roller coaster terrify you? Or are you on Team Nicola with the wind in the willows? We're bringing everyone back on. If we could have all cameras back on now, please. And look at the Christmas hats, decorations. This is fabulous. Hold your horses on voting. Don't make your mind up yet, because we've now got the response stage. Each person has 30 seconds to respond on a particular topic. We've just got Nicola's camera that needs to come back on, please, Nicola. But let's get started in the meantime. We are starting with Eve. Eve, you need to unmute yourself.
Sorry. I'm going also to remove my mask, even though I'm going to talk about the remote trials presentation by Liz. I think we all agree that COVID is the most important event of 2020. However, I find it's a bit of little dubious taste for Liz to try to take advantage of a global pandemic to trying to gain more votes in support of technical issues such as conduct of remote trials.
So, on to me. Was here to rubbish David's pitch on Crown preference, and here's why you shouldn't vote for it. Well, first, it's a terrible idea, isn't it? It really is universally seen as counteracting the other provisions that have been brought in. Put simply, it's stupid, and voting for it is tantamount to voting for Trump. Second, is it that important anyway? I think you can find the answer in the number of insolvencies you've dealt with where there was actually any floating charge proceeds. And third, it's completely irrelevant, to me at least, since Crown preference gets you nowhere offshore.
Sorry, I was having problems with my Zoom. Right, SFO, a national scandal, a complete misunderstanding of commercial nows, basic mistakes are us, the emperor with no clothes, utterly ineffective, so confused as to resemble a field with diseased hares crashing into each other, and finally the seriously flawed office, and most recently the silly ferret organisation. The list goes on. The SFO won't be around in 2021. Don't waste your vote.
Quince Care, what can I say? Rick did a sterling job, but even the name sounds insipid. And what I consider to be the leading authority on this, Fire Magazine issue 3, available at all good bookshops, describes it as a creep in the scope of the duty. How on earth can you think something that's described like that is the highlight of the year? And finally, is anyone going to go to prison at the end of the day? No.
Well, what can I say about SIGA? It's really just a bunch of fleeting provisions. I mean, wrongful trading was hardly ever the claim of choice for us. And moratoriums, restructuring plans, let's see how they really pan out. All I can say, don't believe the hype.
Jen, can you come in on freezing injunctions now? Is that okay? I know you haven't had much notice on that.
Well, I mean, taking small steps forward in freezing injunctions, as outlined by my persuasive opponent, Mr. Klein, was quite simply dwarfed in 2020 by the giant leap for mankind, boldly embodied, I say boldly embodied, in the developments in provisional liquidations in the Caribbean this year. Nothing could be more impactful than that. Go on, you know that voting for me is the right answer. Make provisional liquidators great again.
Search orders and imaging orders. Search orders, not that old, 1974, doesn't go far, doesn't go back too far. There was a muddle over the next few decades. Then you had some CPR changes, which is all kind of quite boring. Now imaging orders, great, very interesting. But it's just, is it not just another laborious and expensive task that us lawyers are going to have to undertake? Also, it was always going to happen. We all knew.
Right, Jen Fox urged us to make provisional liquidators great again. It's very tempting. I mean, it was a good argument. The only problem is the first soft touch provisional liquidation in the BVI has happened recently, but unfortunately it's been happening in England and Wales since at least the early 90s. So it's not really a huge development in that sense. The other problem is the Constellation decision, which Jen was telling us about in the BVI, is actually an early 2019 decision. Awkward.
Okay, we had a very valiant attempt to get through the Marex decision in just 5 minutes, and I recognise the difficulty of trying to rebut that in mere 30 seconds. But I think even Matthew admitted that it's the minority speech which didn't carry the day that was the most interesting part of the decision. Now, since you can't really talk about this case without a Japanese knotwood analogy, I will say it was a gentle pruning of the law and reflective loss when what was really cried out for was a firm uprooting.
Look, I understand the importance of unexplained wealth orders, and I love the poem, Nicholas, so I'll try and respond in kind. Since its inception in 2018, how many unexplained wealth orders have you actually seen? The answer is not many at all. It's an investigatory tool, and that is all. Look, the reality is authorities are using other tools, such as account freezing orders, because it can have the desired effect with, well, less effort.
My response to committal presented by the Mr. Jason Woodland. It's nothing new, save for a couple of insignificant points. New provisions just codifying the rules what was and should have been happening anyway. And what a mess, the court bringing its own case for committal. Who ever heard of such a thing? These revisions raise more questions than answers. More efforts needed, I have to say. And look, where are all your Christmas hats?
Okay, changes to Guernsey insolvency law. Well, from my understanding of it, it allows liquidators to demand documents and interview, disclaim property, chase TUVs, for suppliers to supply. It's exactly the same as the UK already has. It's bringing it up to date with the UK. It's the equivalent of celebrating the fact that your grandparents can now use a webcam. It's helpful, but it's not revolutionary. If you vote for it, you're essentially praising your uncle for cutting off his mullet and binning his shell suits.
Last but no means least, I've got to say to Jason, well, I take my Tinsley hat off to you for trying to, use your soft, gravelly voice to persuade us of anything that is more than a paper-thin argument that services of developments, if any, in service this year have been of any importance. But you were the only person to be cut off after 5 minutes, even though you said you could be talking about it for a whole week. So impressive, but surely not.
Wow, that was amazing. Thank you, all of you. Danushka, could we make the poll live now, please, so everyone can get voting? Thank you. There we are. We've got two there. Remember, just vote in one of them, otherwise it's cheating. What a great way to round up the year, though. So while we wait for the votes to come in, and we'll just give them a couple of moments, I would like to thank the speakers who will perhaps give us a great big cringe-worthy game show wave as I go through them. We've got Liz Horton from Wilberforce Chambers, David Hinrichsen from FRP Advisory, Saeed Rahman from Rahman Ravelli, Rick Brown from HFW, Sinead Harris from Withers, Eve Klein from MBK, Natalie Todd from PCB, Jen Fox from Ogier, Matthew Weaver from Radcliffe Chambers, Nicola Finnerty from Kingsley Napley, Jason Woodland from Peters and Peters, David Jones from Kerry Olsen, and Jason Friedman from Charles Russell Speechley. And our remote thanks go to Vicky Lord from Harneys, who sadly was not able to join us because China. Thank you one and all for your time, energy and enthusiasm. You have made this a really, really great event, and importantly, the easiest chairing task I have ever had in my life. I hope you can all hear in the distance the round of applause that I believe our audience is giving you from around the world. And now the time has come. Thought Leaders 4, can you please release the results of the poll and show us the winning topic? What have we got? We've got a tie. Have we got a... No, sorry, I had to scroll down. The winning topic, Jen Fox, provisional liquidations in the BVI and Cayman. Jen Fox, would you perhaps like to say a couple of words about your prestigious win?
I'm delighted. Merry Christmas, everybody.
Excellent. So I think that's all we've got for you. It's time to wrap up. I think what I'm left with is the great pleasure of thanking you all for joining in, thanking Thought Leaders 4 for hosting, and as John from PCB says, for launching FIRE this year and making all of this possible. And whilst it feels a bit premature to me, though with all of the hats and Santa Clauses on there, perhaps I'm the grouch in this one. I wish you all a very Merry Christmas. See you in 2021. Goodbye.